Hi everybody, I'm Cherilyn from AsiaLawNetwork, and we're here filming live from Spacemob. We're on a series of Q&A with lawyers. This is our mission to bring affordable and accessible legal help to our startups and to everyone in Asia. So before we start, in 5 minutes, I'll just bring you a tour of Spacemob and introduce to you the team and a few people. So they're having a live, right now they're having a web dev class going on. This is at General Assembly. Okay, I better not distract them further. Let's go. So this is a live space at Spacemob. So what you see here is a very quiet co-working space, very beautifully decorated, and you have very cozy areas too. So have a look at the cafe. This is where people get caffeined up. And of course, we have Mr. T here, who is the founder of Spacemob. So he's going to bring us around and introduce to us Spacemob.
I will try to do that. Hello, everyone.
Hello. Oh, sorry, yes.
You're going to pass the mic to me? All right. Very professionally done, this piece, all good. Let me see if I can hear.
I think you just hold it.
I can hold it, right?
Yeah.
Okay, I'll just put in the little thing here. How's that?
Yes.
All right. Okay, everyone, where we are right now is the event area of Spacemob. It also doubles up as a pantry, F&B pantry. Today, we have the guys kind of away today because today we have an event for our members. We call it Tapao Thursday.
Nice.
Where we actually take out food from one of the best hawker centers in Singapore, bring it here where all our members can kind of enjoy. So some leftover stuff here. Right. So for example, we have the Adams Road Nasi Lemak, we have the Old Changi Road Hokkien Mee, and some great nasi padang actually from Far East Plaza, which is very close to us.
Cool.
So we actually do this every Thursday, every Friday.
Oh, nice.
Beers, alcohol, and whatnot.
So you mean if I co-work at Spacemob, this is some of the perks that we
some
have?
of the perks that you guys have. Yeah. You'll see some lockers here essentially. So all our members here have access to lockers. They are free to use per day, but you can rent it out for weekly, for monthly, for yearly as well.
Right.
The space itself is about 15,000 square footage. It fits about 400 desks altogether.
Wow. Okay.
Right now we're about 85% filled.
Right.
We've been in operation for about 2 months now. So it got fast occupied pretty quickly. But what I'll show you is a few little nice features that we have in our co-working space.
Okay.
So right kind of in the middle of the building here is the sort of the meeting rooms. Every single doors are basically locked, accessible by card or by our phone itself. Nice. So you can kind of book the room. We get some credits for our members to use on a monthly basis. Some of the things that we are really proud of is the things that we actually built into the office. So all this booking facilities online and also on the iPad here is all built by us. So if you want to book this thing for 1 hour,
right.
Basically type it right there, and every single member has a QR code, so you can tap it right there to sort of book it. Right.
Okay,
so
that's easy.
So every single thing from the physical aspect of things, the digital side of things, is all built by the team itself.
Fantastic.
Right? We make sure that this is something that we want to keep it very efficient for our members to use.
Right.
This.
Could you tell them we're going to start in 2 minutes?
Oh.
Tell the audience.
We're going to start in 2 minutes? Oh, you guys are going to start in 2 minutes? Oh, okay, yeah, we're going
to start in 2 minutes.
You guys can start in 2 minutes.
Sorry.
Oh, no worries. So this is the fixed desk area, right? The fixed desk areas are basically seats and tables for people who will be here for a slightly longer term basis.
Right.
Minimum membership is about 1 month.
1 month, okay.
What we give them is basically a table, a locker, and Herman Miller chairs, which is very comfortable, great for them to sit on. Right?
Yeah, especially startups who spend a lot of time working.
Especially when they work. And they have this place accessibility with 24/7 access for these guys here itself. Okay. You want to go back to that thing now? All right, let's go back to the GA section so you guys can see what's going on there. But quickly, these are the flex desk area. So this is sort of first come, first serve. You guys can kind of use this space at any point in time.
This is like hot desking.
Hot desking, essentially.
Oh, okay.
Let's just slow down.
Yeah, there you go. So there's a hot desking. So different folks who work here, they're usually more transient. So whenever they need a space here for a few weeks, a few months.
I see that people can doodle on the glass.
Oh yeah. So the whole idea is all very, there's not a lot of opaque walls in this
Right.
place, so we want to keep the place kind of open. So if you stand here, you can kind of see what's going on over there. If you stand in that section, you can see everything around the section as well.
Okay.
So all offices are kind of glass as well, and they can write on the glass. When inspiration comes, right, you need to write down your ideas and whatnot.
It's not with permanent markers, of course.
Hopefully not.
Okay.
But here. Right, cool.
Thank you very much, Mr. T.
No worries.
Thank you for your tour around Spacemob. So,
Thank you.
if you guys are looking for a great co-working space, spacemob.co.
Yes, spacemob.co. Come check us out. Thank you.
Thank you.
All right, thank you so much.
so much.
All right, I'll give you guys the microphone back. There you go. Enjoy.
you. Great. We're going back. We're going back to where we're filming. So we have a great team here that will be facilitating our today's Q&A, live Q&A session. So of course, sitting there is our guest of honor, Samuel Ng from BlackOak LLC. But of course, we have a great team here. We have Kenneth, Daryl, Kevin, Wilfred. They're from E27 and Pihon from AsiaLawNetwork, of course. Okay, once again, if you just joined us, I'm Cherilyn from Asia Network, and we have here Samuel Ng from BlackOak LLC. This is the first of a series of live Facebook Q&A with lawyers. This first session with Samuel is on tips for the startups, and Samuel has a keen interest in startups. Maybe you can tell us where they came from and tell us a bit.
First of all, I'm Samuel. I'm from a firm called BlackOak LLC. Like the people we're talking about today, we are also a startup.
Yeah.
We started our firm sometime in April this year, early April.
Oh, that's nice.
Yeah, so it's been less than a year in fact.
Okay.
I wouldn't say that the same issues we face would be the same issues that both startups face because we're quite specialized.
Okay.
But the fact is that we have a lot of friends who are also starting on their own. I think the millennials are all starting interesting businesses, be it in tech or in F&B, so on and so forth. I'm really quite interested to see how things will grow. And the nice part about being involved in helping startups is that you see things grow from nothing to something and hopefully into something bigger. It's quite different from your usual daily litigation job where it's quite destructive.
That's true. Okay, we shall not go too much in the destruction part. So today, very interesting, we have a number of questions that are posted by you guys who have signed up earlier on. But before we go there, for those who have just joined us again, this is Cherilyn from Asia Law Network, and today we have Samuel Ng from BlackOak LLC. A great shout out to our partners from E27, from General Assembly, Startup Bootcamp FinTech Singapore for promoting this event in conjunction with our whole series of Facebook Live sessions that's going to come up in the next 4 weeks. So do tune in when you're free to help answer some of your startup questions on the law. So Samuel, again, back to some of the questions we've had. We polled a few Facebook groups, and some of the more prominent questions came up. So we're just going to discuss broadly on those issues first before we go into separate verticals. So one of the most commonly asked questions in the Facebook groups, as well as from most startup founders, is that when we go into, for example, a founder's agreement, what are some of the things you will look out for? And how do we go around navigating issues around a founder's agreement, especially when it comes to two, right? Do we go in and say, hey, this is going to be a 50-50 thing, and how should we even start?
Okay, first things first, I think what sorts of legal issues a startup will face depends really on what industry the startup is in. Is it in tech, or is it in actually creating a product, or is it in service, for example? Now, depending on that, your shareholder agreement might be different. The contents will be different. The document will still be the same. There's still a shareholders agreement or founders agreement. Perhaps I should just say, for those who do not know it as much, the founders agreement is usually what people call the document that governs the relationship between the people who found the company. Shareholders agreement might come subsequently, or they might be the same thing, but the considerations are quite similar, so I think we can deal with them together. Now, when it comes to starting a startup, and as you mentioned, people come and they say, oh, we want 50-50. That is a remedy for failure.
No 50-50s.
No 50-50. The simple reason being that if 50-50 and we have a shareholders meeting and you say yes and I say no,
what's going to happen?
What's going to happen?
Yeah. We'll tear each other's hair
Yeah.
out.
And that really comes down to how people approach setting up companies. I know we're moving towards a more flat structure in working. We're moving to something that's less hierarchical and more collaborative.
Right.
But unfortunately, as well-intentioned as that may be, that might not sometimes work.
Right.
I think people need to realize that while everyone can be friends and be partners, not everybody can be a co-CEO.
Right.
And not every decision needs to have the unanimous approval of everybody.
Yes.
Right? I think that needs to be made clear from the start.
Yeah.
And on that basis, you then start to allocate responsibilities to parties who are coming together to start this new venture.
Right.
You start to allocate responsibilities, duties, and from there you can sort of get a sense of where shareholding will fall. Of course, there's always a question of, okay, why should you get more of the shareholding and me less?
Yeah. Yeah, that always happens.
That
right?
always happens.
Like, why am I contributing less?
Yeah. But most of the time, interestingly, I realize that a person, let's leave investors aside for now, okay? Let's just say at the start, the person who gets the majority of the shares will be the person who started it with the idea.
The idea.
Yes, because then everything starts being discussed on his terms.
Yes.
Like, I want to do this, I'm inviting you. What can you contribute? And we'll see how we apportion it from there on.
Right.
Of course, there will be some give and take. People need to be a little bit more transactional and be a little less emotional when it comes to these things. So it's really just horse trading and bargaining. I might give up a bit more of the shares, but in return, I might want to have, say, veto rights over certain matters as a director, or I want certain things to be put into reserve, so we need unanimous approval, or maybe 75%, 80%, whatever it is.
Right.
So these are really some of the things that you need to look out for in shareholders agreement. I know a lot of people think, okay, it's a simple agreement. Maybe I pull a template off the net. I
Right.
would just tweak it as we go along.
Yes. Recommend it? Not recommend it?
No, self-interest aside, vested interest aside, I really wouldn't recommend that.
Right.
Okay. As lawyers, we are trained to look out for risks,
Yeah.
especially in BlackOak's subspecialty, which is really in special situations or distress. We see a lot of companies that are near distress or in distress, and our job is usually to either to resuscitate them from the brink of death, or we put them down in a very clean manner.
Right.
A lot of that sometimes happens because things are not as well thought out from the start. Now, it's better if we can deal with them from a more preventive point of view than a reactive point of view, such that we don't have to then take things as they come, you know. And it gets a bit harder. You can just predict a lot of things that are happening and just try to prevent those things from occurring.
So this is very interesting, right? As founders or as startup founders, what we think of as possibilities, what are the things that we can do for the world, how our idea is going to change the world, how this is going to change the way people live. But we don't often think about what happens if it does not work out. What happens if, you know, for example, the co-founder you found does not work very well with you. How is he then? How can he then be fairly treated? You know, even if he leaves, right? That kind of things. So I know that lawyers do a different kind of advice. They are basically trained to think of problems in terms of risks, right? So maybe you can give us an idea, like a few examples of how you think of risks in a startup and how that can be structured into an agreement.
Okay. Actually, there are a lot of risks.
Yeah, that's
and
true.
I think we'll probably be dealing with some of them later, maybe in the context of employment or whatnot. But let's just take it from the shareholders agreement at the start,
Investments,
right?
maybe
Okay,
founders,
let's say,
and they put in some money.
yes,
for example.
okay. Everybody comes to the company expecting it to succeed. Nobody expects it to fail.
Yes.
But the truth of the matter is that a lot of startups fail.
Yes.
That is the ugly truth of the matter, right?
Yes.
Unfortunately.
Yes.
What we want to do is to make any change in mind as painless as possible.
Right.
So some people might come into the venture and then decide maybe one year down the road, I want out. What happens then? You need to cater for scenarios like that. What happens to my shares? Do I have the right to force them on you?
Yeah.
Or what do I do? How do I value those shares then?
Yeah.
Do I sell them back at nominal value because you're punishing me in the agreement?
Exactly.
Things like that just need to be planned. So actually a lot of risk. This is the reason why people engage lawyers to come up to think of things like that. In fact, we're a bit like the devil's advocate.
Yeah.
We just tell you everything that may go wrong,
Yes.
and let's try to prevent that.
Yeah. Actually, one of my most hated sessions with lawyers are basically looking at all the things that can go wrong. So if you're just joining us, I'm Cherilyn from Asia Law Network, and this is Samuel Ng from BlackOak LLC, and we're discussing tips on how startups can improve themselves, knowing what they can do with the law. So if you have any questions, please feel free to post them in the comments section below, and we'll try to answer as many as we can today. So, okay, back to what we're talking about, right? Like, for example, if someone, when founders go in together, they will not know whether they're going to come out, right? One is going to leave earlier than another. So I was told and advised by some people would be one of the ways to structure the contract would be, for example, if in a year you were to leave, you'll get either a sum of money in exchange for the shares that you have, or and that number has to be specified so that there's no ways of arguing that. Is that something that you would recommend to do?
Okay, let's take it from a neutral investor point of view.
Yeah.
Because the principles are similar.
Yes.
Say you have been very fortunate and you've managed to find an angel investor or just somebody who wants to invest, but quite sophisticated person or organization.
Yeah.
Right. Usually you will have a vesting period for the shares. What this means is that yes, the shares are supposed to be yours, but you don't actually get them, or you get them but they have the right to be recalled until certain milestones or timelines are met.
Okay.
There are certain terms being used here, things like cliff and vesting period. So a typical example for a neutral investor might be a 1-year cliff and a 4-year vesting period. What this means is that, okay, for the first year you don't actually get the shares you're entitled to finally. Right. But upon finishing that cliff, that 1-year mark, you get the first part, 25% of what you're entitled to, and then the rest will be spread out evenly across the next 3 years.
Okay.
It could be on a monthly basis. Now, instead of timeline, this could be tied to milestones, like if you achieve certain R&D or certain products. But of course, that makes it a little bit more difficult to judge. Of course, going on timeline is a lot easier. These are ways to incentivize people and to make sure that interests are constantly aligned, at least for a definite period of time, after which you can more or less get a sense of where the company is heading.
Right. Okay. Interesting. So I think we're touching a bit on the shareholders agreement here, right? Where we talk about cliff and vesting periods. So just again to recap what we have said earlier, 50-50 definitely between founders is a no, because you hit basically a roadblock where you cannot agree on each other. So what are some of the other things you spoke about which we can negotiate on the table? Things like, for example, veto rights on certain decisions made, right? So other than shares, you have to think about what are the veto rights you want on certain parts of the decisions of the company.
Reserve matters.
Yeah, reserve matters. Okay. What are the other things founders should really trash out from the start?
For example, what happens if some investor, let's say I'm the majority, it happens that I'm the majority and you're the minority. Investor comes along, and because of my votes and because of how the decisions are being made according to your shareholders agreement or your constitution of the company, I want to go with that investor. I want to sell the whole company to the investor because the investor is not going to just buy me. He wants to buy the whole company. That's where we bring up terms like drag-along rights, tag-along rights. Drag-along rights is basically something that majority will use. That, okay, I'm the majority, I'm going to exercise my right to drag you along into this new setup or this new sale against your wishes. But the flip side of that for the minority would be the tag-along rights. That, okay, they want to buy you out, I want to make sure that I get a say, that I want to come along.
That you also get to sell your shares
Yes.
and get some money in
Yeah,
return,
so
right?
I don't get left with somebody I don't want to deal with.
Yes.
We might be friends, but you know, you see a better friend and I don't know your better friend.
Yeah, that will be a horror
Yeah.
story.
And it comes to decision making, let's come back to that. When it comes to decision making, let's say it's a real deadlock, okay? After you sort out all these things and it's still a deadlock.
Right.
You have to cater for deadlock provisions. What happens then? Sometimes we have a cooling period. Singaporeans would be quite familiar with what a cooling period is.
Yes.
Or just basically a period for you to think and to sort things out where
Right.
you can't really activate the rest of the clauses that follow.
Yes.
After the cooling period, if you still can't reach a resolution, that's when the other clauses will come into action. Some of these clauses might be things like, okay, call option, put option. I can force you to sell your shares, or I can force my shares on you,
Right.
because we can't agree on certain important matters.
Okay.
That could be the reserve matters, for example. Or I could liquidate the company. We will agree to liquidate the company because, well, we just can't agree anymore.
That's interesting. So we actually have to think about all these things even before starting a company. You have to start thinking about whether you want to have drag-along rights, tag-along rights, even as a minority, right?
It's very depressing, really, because everybody goes in wanting it to work out. We're all going to be friends happily ever after. So let's not think about these nasty things. But the fact is, you have to deal with them.
Yes.
If not, you
Yes.
get a lot of problem on your hands later on.
And of course, you lose friendships along the way, right? If you discuss this right from the start, then of course, when things happen, you know exactly what to do.
Yeah, and I guess that's the reason why for maybe companies that are a little bit larger, when they're negotiating a JV, they will always have their own counsel present,
Yes.
even if they're friends. Because you see, you have a neutral party, a more objective party, and then basically a party whom you can just say, oh, I was advised by my lawyer.
Yeah.
You know,
hide behind.
Yeah, you can hide behind your counsel in that sense. It's
Yeah.
easier for two objective neutral parties to speak.
Interesting.
Yeah.
I also know that lawyers can be hired to do negotiations.
Yes.
Right. So
Yes.
I think that's a case where, you know, if you have to negotiate with, for example, a potential investor, or a counterparty who's trying to buy you, or you're trying to buy someone else out, you can always hire a lawyer to help you do the negotiations.
Yeah, I think that's actually where the real value add of lawyering comes in, because otherwise everything can be done by robots, right?
Yeah.
This is a very human thing.
Yes.
Lawyer to lawyer, my lawyer might know his lawyer, so maybe they have a special relationship, they can
Right.
reach settlements quickly.
Yeah.
Or my lawyer can look out for issues that I can't look out for on my own.
Yeah. Is this like a Suits? A scene from Suits where you go,
I think
Here's the
nowhere
deal.
is brutal. I
Okay.
would like to think that we are a lot more accommodating here in Singapore.
That's true. Thanks. Okay, just a quick recap of what's happening right now. We have some questions coming up that might be interesting. So we have a question coming on from our Facebook post. What are some of the practical issues I must bear in mind when setting up?
Okay, when setting up, I think apart from whatever's been discussed,
Yeah.
and this is not so much law, but it's still important. I think when assessing how much to spend on lawyers, on legal services, whatnot, ultimately you must think, what is the purpose of all this legal documentation? Do I just want to put things on record in a very clean manner
Yep.
to give it some sense of formality? Or do you actually intend to have something that can be used against the other party if something goes wrong, to
Right.
enforce?
Right.
I'm asking this question, I'm saying that people need to ask themselves this question because the costs sometimes of enforcing your rights might make it not worth the while.
Yeah, that's true. To take
Yeah.
someone to court, it's going to cost way more, right,
Yes.
than, for example, having a resolution on the contract already.
Yes, in fact, this cost-benefit analysis really takes place every day in our lives. We do this subconsciously, but even in law, we have economic theory of law, economic analysis, and how things go about. This concept called efficient breach. It's a very simple idea. Basically, if I take the view that I do some calculations, and it's better for me to just breach this contract and pay the damages
Yeah.
and continue elsewhere. Let's say if I'm changing suppliers or changing places, rental places, right?
Yeah.
My venue. Yeah, it might be more worth my while to do that.
Right.
Yeah,
right.
so it's really cost-benefit analysis. This is also the reason why sometimes in businesses, when you try to collect on debts, and the person, in Singapore we call it Chao Kwan, just refuses to pay, because he knows that you will not pursue the debt.
Yeah, it doesn't make sense.
Especially if it's an amount above, let's say, 10,000,
Yes.
which is beyond the small claims tribunal's jurisdiction unless they agree to it. And then you think, okay, how do I do this? Do I send a lawyer's letter? That's what, $100,
$200,
$200
yeah,
for
yeah.
very simple, straightforward copy paste kind of work, he's
Yeah.
not going to bother. So what am I going to do? Okay, maybe his company is, I think the view is not doing well. I want to wind him up.
Right.
Well, your disbursements alone are going to be about $10,000,
Yes.
and you have no promise of getting that money back. Yeah, I mean, some very famous, very, very famous world businessmen have built empires on.
Yes.
Yes.
So I've heard and read. Okay.
Yeah, these are very real concerns. So again, yeah, you have to think of enforcement issues. What are you going to do? Yeah.
Okay, so it doesn't mean that when you write something in a contract, it is an option you would take later on because it might cost you more. So why don't think about what are some of the issues that you may use or tactics you may use to counter those, and think about your risk first, and not think about how you're going to enforce those
Yeah.
when
Yeah.
the contract is breached, right? Okay, interesting. So just now you spoke a bit about majority minority. I think in Singapore's context, we have, of course, the ACRA gives you a very simple M&A that everyone uses, basically. And if I'm not wrong, the simple majority just means majority in shares.
A majority in number, yes.
Yes,
I
in
mean,
number, right?
For shares,
Yeah, for
majority,
shares.
simple majority, above 50%.
Okay, and if the shares are split, I mean, the company is split amongst like many different parts, so the majority would be the person who holds the most shares.
Yeah, or the moment, let's say you need to pass a resolution or ordinary resolution, as long as you get enough people on your side to push it over the 50, then that decision is passed.
Correct.
Yes.
Okay, interesting. So we've had some questions coming in, so let me look at them. Here's a very cool question. What kind of lawyer would make the best lawyer to negotiate through a funding deal? Is it a litigator or a corporate lawyer?
Ooh, this is very sensitive. I think ideally you want somebody who has experience in both,
Right.
right? Because when you come to negotiating, it's a lot of give and take.
Right.
You need somebody who is able to have a pleasant face, who can actually get the deal through for you, but who is ready to back you up in court if the deal doesn't go through.
Right.
Let's say I'm assuming you're not negotiating a new deal, but negotiating an existing deal, for example.
Right.
Yeah. So you want that person's reputation so that the other side also knows that, okay, this person is playing friendly, but he has an arsenal. I know he's going to come after me if something happens.
Right.
Yeah.
Okay. Interesting. For those who just joined us, once again, this is AsiaLaw Network's series of Facebook Live sessions with lawyers. And we have here Samuel Ng from BlackOak LLC.
Hello.
Answering questions on tips on the law for startups. So those who have questions, please type into the comments box below so that Samuel can answer some of your questions. So we're talking about like lawyers and how whether they're good negotiators. I have a friend who basically hired a lawyer because he lost the case to that particular lawyer.
Oh.
So in his next case,
This is not uncommon. This is not uncommon.
uncommon.
We have had that experience.
Right,
Yes,
right,
before.
right. So after you win a case, the opposing side actually hires you
For a completely different matter, of course.
for a complete.
Yeah.
Okay. Can you tell us a bit about how in this whole practice of law, there's this thing called conflict, and I'm not sure whether startup founders know, but when it comes to legal matters, it is quite sensitive. And lawyers often have to do a conflict check on the people that they represent. So can you tell us a bit about the process and how that can affect which lawyer I look for?
Yes. So, see, conflict works this way. It's a matter of ethics. We can't act against people in the matter we can't act for the people in the matter if we're already acting against him in a related matter.
Right.
Because it's just unfair what knowledge we have and what not. This is from an ethical point of view, is plainly wrong.
Right.
What happens when you engage a lawyer is that he needs to make sure that he's free from conflict.
Right.
If the firm is sizable, medium-sized, large-sized firm, there would be an automated record of clients.
Right.
We can actually check that through the client database.
Right.
And we follow that up with an email to everybody just to make sure that nobody's conflicted, because you never know, somebody might be a family member of the company on the other side, on the opposing side.
But how
so on and
far
so
does it
forth.
go? Like family member? That means, like, for example, if my mom or my dad is using a
We
certain
wouldn't,
lawyer.
yeah. I mean, personally, we wouldn't if that's the case.
Right,
Is
right.
that the case? Yeah.
So it's important to find, of course, a lawyer with arm's length, right?
Yeah.
Relationship with you or your family members, so that he or she can act in the interest, in your interest.
But interestingly, this also gives rise to a phenomenon of people conflicting out lawyers deliberately. It's a strategy that some people have suggested that they can be adopted.
Right.
I don't know whether it really can be used, or some people have thought of, okay, I'm just going to go around to the famous lawyers in the industry I'm going to operate, and I'm just going to go there and keep each one of them on some retainer and do a little piece of work for me here, there.
So then they cannot.
And then next time people kind of engage them against me.
Right. Okay, let's hope we don't go there. And also the good thing to know is that out of the 890 firms in Singapore, 82% are small law firms. So which means 5 lawyers or less. And there's plenty of lawyers to go around. And we have very good lawyers that are working in smaller firms. They're more nimble and they're able to respond.
And definitely much more conflict-free by default, usually.
Yes. Okay, great. So we have another question that's coming up that is actually relating to some of the things that we're going to talk about. We are covering some parts of the shareholders agreement where you were talking about the cliff, about, another topic that's very interesting is ESOP. Employee stock options program.
Yeah.
So I think for startups and startup founders, we often talk about this with our investors. Do you have anything to share with regards to ESOP, like what is a typical kind of arrangement and how we can go about executing that? When should we even start to think about it? Like, it's very weird to think about an ESOP program when you can't even get your founders agreement right.
Yes. Intuitively, ESOP sounds like something very far down the road. Like, wow, I'm going to expand, I'm going to go regional, and I'm going to have 200 employees, and some of them are managing directors, my senior managing directors are going to get shares.
Yeah, that's...
So yes, it can sound a bit intimidating at the start, but there are companies who do plan for ESOP from the get-go, because they have a more or less clear idea of where they want to be 5 years down the road, 10 years down the road, or even 3 years down the road, simple ESOPs. One way of doing it is to set aside a percentage of the shares for the ESOP. That doesn't mean that you have to grant the ESOP at the point at which you set them aside, but you make provision so it's easier to deal with at that point in time.
Right.
But of course, the moment let's say the ESOPs are going to be ordinary shares, then when you start giving away the shares, then the question of how much the shares are worth are things you need to consider.
Yes.
But simply put, you can plan to have ESOPs from the get-go. You don't have to work, you don't have to act on it immediately, but you can plan for that.
What's the typical percentage that you plan for
let's say
ESOP?
5 to 10% of the company's total shares to ESOP. With
Total
5%
shares
maybe.
today or total shares in the future?
Well, you can have total shares today,
Okay.
but you have to take into account, of course, valuation issues subsequently. But ESOPs is one thing. Ultimately, the question is how you want to remunerate your employees to align their interests with yours. Everybody wants to feel like they're parts of something and that they're not just workhorses. They get rewarded proportionately based on what they put in and how the company is doing.
Yeah, especially when in startups, like everyone works like mad, so you want to be rewarded more than just a normal employee, right?
So I think it's important for you to know, for startup founders and for bosses to know who exactly your employees are and what their needs are at any given point in time. For example, if you're hiring employees to build strength in the different areas, normal employees,
Right.
and you think this person shows some promise, I want him to stay with me because I don't want him to go to a competitor, for example. One possible document that I've worked on before, and this is, to my knowledge, not as common in Singapore as it is in overseas, is what we call a phantom share arrangement.
Phantom share arrangement.
Yeah, it sounds very ghostly.
Yeah, that's cool.
Yeah.
That's the first time I'm hearing this. So let's talk about
Okay,
it.
a phantom share arrangement is purely contractual.
Right.
I must stay up front, no real shares are being transacted.
Okay.
No real shares.
That's why phantom shares.
Yes. Exactly. That's why phantom shares. This stems from the idea that maybe at the start, the primary concern of employees is cash. How much am I getting paid? Why am I not getting paid a very clear bonus based on what I put in? Why must my bonus be a discretionary sum or a number of months?
Right.
The function of a phantom share in this regard is to mimic how an ordinary share will perform.
Right.
In other words, I get treated as if I were an ordinary shareholder, almost as if I were an ordinary shareholder when it comes to dividends.
Right.
But it comes with none of the responsibilities. It doesn't
No
come.
voting rights.
No voting rights, exactly. I'm glad you picked up on that because that is actually the sell point for the employer.
Yes.
Yes. Of course, the sell point for the employee could be that I don't have to be bothered in the day-to-day management.
Yes.
Yes. But how it's usually done is through a normal scheme document, share scheme, and then you have an offer letter, acceptance letter, and then that's it. Issue a phantom share certificate to you.
Right.
And this phantom share thing could terminate immediately upon the person's resignation or certain events of default. And
Right.
whether you want, how you want to give these shares is also up to you. Usually these would be given FOC, at least for the ones I've done.
Yeah.
It's given for FOC or nominal consideration, nominal payment, very nominal.
Right.
Yeah, because honestly, these are not real shares. This just rewards you based on how the company is performing.
So is it like a profit sharing type of arrangement?
You could see it as a bit of a profit share in that sense.
Yeah.
Yes. Ultimately, the discretion is still with the board as to how much they would declare, how much funds they would declare to form this phantom share pool, right?
Okay.
But at least you get clarity as to out of that pool, what percentage you will have.
Yes.
Right? It's not an arbitrary number. It's an intermediate ground. It's particularly useful if you don't know whether this person is 100% suitable to be a shareholder, which comes with its own problems, as you've identified.
Right.
But you want to put this person on a path towards eventual shareholding, real shareholding.
Right.
So the scheme document might have clauses that say, these are issued to you. Within the first 2 years of you being a phantom shareholder, your performance will be assessed, and we will see whether you are deemed suitable to progress onto a proper ESOP.
Right.
And the best thing, of course, is that it's cheaper, I think, to execute overall this phantom share arrangement.
Right. So who issues the phantom share certificates? I mean, like share certificates are usually issued by the CorpSec, right? The company secretaries. So what about this phantom?
You could also get the CorpSec to do it. You could get the board to do it. I mean, honestly, it's not a real share certificate. It's just a document to show that you are entitled to certain things. It's just a cash benefit.
Okay. Cool. Well, we have a question coming in. So, interestingly, someone's asking, what are some of the typical rights given to minority shareholders in terms of consent, veto rights?
Okay, let's say minority shareholders, if you get, just thinking off the top of my head, a neutral party investor who's okay coming on as a minority or an advisor, it depends on the context. It might be the case that he wants veto rights over certain matters. He wants final say because his share is so small.
Yeah.
He doesn't want you to be overridden on a lot of decisions.
Right.
Of course, it's all give and take. So yeah, veto rights is one possible area to explore. Whether that will actually happen in reality depends on the context and who this minority shareholder is. Is it just a friend of yours, or is it going to be an angel investor whose monies are at stake and you only have your sweat equity to lose?
Yes, exactly.
It's all very different. But the thing is, minority shareholders, under Singapore law, we have a remedy of minority oppression when decisions are made without regard to their interests.
Right.
Of course, these lawsuits are all very expensive.
Yeah.
Another cost-benefit analysis thing for people to think of there.
You might want to crowdfund your legal fees. No, okay. Sorry.
So minority, people do ask for veto rights. People do ask to place a representative director on the board. These are all possibilities that can be explored.
So we have spoken about like majority minority, right? So one of the things that we can negotiate for is veto rights. Another thing is directorship, right? So if you're a minority shareholder, you can negotiate for directorship on the board, or even a chairman position, you would think? If you have more than, I don't know, 5 directors.
I don't know whether that's very realistic.
But in the case of like the example you brought about, where the angel investor is the one that put in most of the money, right? But the angel investor is like 30%.
Yeah, I've seen angel investors that will request for veto rights over certain matters.
Over certain matters.
Yeah, or rather you could see as a veto right, or you could see as a very consultative process. They want to be consulted based for certain issues like where the company is heading, growth plans, expansion plans, financing definitely if there's an angel investor.
Okay. Well, for those who have just joined us, once again, this is Cherilyn from Asia Law Network, and sitting here with me is Samuel Ng from BlackOak LLC.
Hello.
And we're discussing tips for startups when it comes to the law. And Samuel is a lawyer. He's going to answer most of the questions that you're going to post down here today. So post the questions in the comments box so that Samuel can answer them. We have some other questions coming in. So what are some of the considerations I need to bear in mind when a VC wants to invest in my startup? How do I go about deciding how many shares to allocate to a VC?
Okay, VCs are interesting creatures, and a lot of startups that I've seen don't really understand what their bargaining position is in relation to VCs.
Yep.
First of all, I think startups need to understand that VCs see startups like them day in, day out, dime a dozen.
Right.
Every startup likes to think that their idea is super unique. Like, I'm going to be the next
I'm the only
Facebook.
one.
Yes. But that is more often than not, unfortunately.
Yes.
Sorry to be a wet blanket, not the case.
Yes.
Right? So you have startups going to VCs, first thing you say, I don't want to talk unless you sign an NDA. That's not going to That's not going to fly.
Yeah.
Yes. Usually NDAs will be reserved for more potential business partners, manufacturers or contractors. With VCs, unfortunately, I think bigger bargaining chip is with them, not with the startup, which means that things like control would be quite tightly circumscribed. Things like sale processes for existing shares or share sales going forward are going to be strictly confined on the terms by the VCs.
Right.
Yeah, but they can be quite useful if you find a VC that believes in your product and is willing to invest in you all the way.
Yeah.
Yeah.
Okay. So is that something that startups should look for? Follow-on investments, and is it typical for?
It depends on the mentality of the startup founders. Some startup founders go in and they say, okay, that's it. I want an angel investor. After that, I want the VC for my Series A, Series B, so on and so forth after the seed. Some people are less willing to part with control,
Right.
especially because they are afraid that their brand will be, in a sense, diluted or interfered with. They have a very strong vision of how they want things to be run.
Right.
Of course, that would mean that your growth will be a lot more organic and slower in that sense. There's no right or wrong. It depends on the industry. Especially, I find startups in the creative industry or in fashion, they might want to retain a lot of creative control over how the company progresses and how to scale it and what scale they want to keep it at. Rather, some people like to be a little bit smaller if they're more artisan in nature.
Right.
Again, it comes back to it being important to find a VC that really is aligned with you.
Yeah.
Remember that while the bargaining position is stronger on their side, it's not just a one-way process. It's like all interviews. They are interviewing you. You are also interviewing them.
So in the case of how do I go about deciding how many shares to allocate? I think we also have to think about where you want to end up at the end of your Series B, for example, right?
Yes.
Will you still hold majority shares? We've heard of so many startups that raise funds over the course of a couple of years, and at the end of Series B, they're left with less than 10% for themselves.
Yeah.
Right. Then
it's not a problem if the market value of the shares are tremendous. A small percent of a big pool is still better than a big percentage of a small pool.
Of course, yeah. So the key is, of course, to balance that with your valuation and to see how your company is moving, right?
Yes.
So another question here: are foreigners able to start businesses? I assume in Singapore.
Yes, Singapore is very, very friendly to businesses in general.
Yeah.
But one peculiarity, actually it's not a real peculiarity because it's quite expected. But one thing to note is that if you are going to incorporate the local company, you need one resident director.
Right.
One director who's ordinarily resident here.
Right.
Could be a PR, could be a citizen. In fact, there are a lot of corporate secretarial companies out there who offer this kind of directorship services, and the independent director. for example.
Okay, cool.
Yeah.
This is very interesting because we had one request coming in from ALN. So this question is coming from Lim Yin Lee. So Yin Lee, if you're listening, yes, foreigners are able to start businesses in Singapore, except that you need to find a local director or partner, right?
Yes.
And you can find that with corporate secretaries. Can we find that with lawyers though?
There are firms who provide CorpSec services.
Right.
As to whether they are comfortable with sitting as directors is a very different question altogether as independent directors.
Right.
Yes.
Will that cause, like, do we have to do conflict checks then as well?
Oh, definitely.
Right.
As lawyers, if I'm not wrong, if I'm still recall it correctly, we're not supposed to hold executive positions in companies. Independent directors are probably okay, but not executive directorships.
Right.
But even if you're a foreigner and you want to be controlling the business, you can. You can. You need a very special document called an entree pass. It's a portmanteau of two words, entrepreneur and pass, entree pass. It's actually the details are all online on the MOM website, and it's very clear as to what conditions need to be fulfilled for you to be eligible. There are certain industries that don't meet the requirements, like it's just, I can't remember off the top of my head, but there are certain sectors of industries that are not eligible for entree pass, and you need to be, one of the conditions is that you need to be funded or approved by some government approved VCs, for example.
Okay,
Yeah.
That's interesting. So if you're foreigners, don't be afraid. Singapore is a very easy and fast country to start out a business, and you can find corporate secretarial services that can help you with your local partner or director, right? And also for some lawyers. Just to recap again, a quick shout out to our partners, E27, General Assembly, Startup Bootcamp FinTech Singapore. Thank you for partnering us in making this happen. So we have here Samuel from BlackOak LLC.
Hi.
And okay, so and we have questions coming up. So don't worry if you are. Please keep the questions coming because after this we'll still try our best to to answer all your questions. Okay. So we have one question coming in from Kenneth Chu. Is it pragmatic or even useful for early stage startup founders to apply for a patent on their ideas? And how should they go about it in Singapore?
A patent on their ideas, I suppose this is more tech-based than more tech or product-based.
Is it pragmatic?
Is it pragmatic? Okay,
it depends on the startup.
It really depends on the startup and the idea that you're seeking to protect. Again, it's good to consult an IP lawyer from the start.
Yes.
Because not everything can be patented.
Yes.
For example.
That's true.
Yes. You think that, oh, I have this genius idea and okay, that's it. This is going to be mine. I'm going to write it down in an envelope and mail it back to myself to prove that I'm the first person.
Right.
But no. Things like IP rights, secretarial, for example, and maybe there's already something existing that's similar.
Somewhere else in the world.
Yes. So it's good to explore these issues from the start. As to whether you need it or not, I think it's very context specific. It's good to explore, definitely. Please seek an IP lawyer, a good one.
Yes.
And
very
be able to get your
interesting.
advice.
Yeah, we do have a session with Ying Yu from Via Law. This coming 30th November, same setup, basically a Facebook live session Q&A, and you can basically find out your answers from there. So watch out for that session. At the same time, please if you want to sign up for any of our Q&A sessions, please go to x.AsiaLawNetwork.com/FBLive to sign up for the other sessions that are coming up. So let's go to some of the other questions that are coming in.
Sure.
Okay, this one also relates to the Ying's Facebook Live episode that's coming up on the 30th. Lydia Ng asks, NDAs and IP remedy clauses, practical or useless? How enforceable if staff operates out of Singapore, little or no protection for founders in such instance? We'll keep this question for the 30th, so Lydia, stay tuned, okay? Okay, we actually spoke about this. So Po Chen Wei actually asked, how do you enforce an NDA in Singapore? We were talking about NDAs early on, just now. And we're talking about when you should actually use them and whether they're enforceable. So maybe you'd like to give us an idea what.
NDA just protects what is deemed to be confidential information. In the event that that confidentiality, that non-disclosure agreement is breached, you could have a variety of remedies. Let's say damages, which is very general.
Yep.
Or in special circumstances, you might be able to get an injunction. An injunction is just a court order to either force somebody to do something or to tell somebody to stop doing something.
Right.
Yes. So those would be your remedies. It can be quite expensive sometimes to enforce an NDA. Again, it's a cost-benefit analysis sort of stuff. The fact is that you should still have an NDA at the appropriate juncture, because people will always find it more difficult to consciously breach something that has been signed.
Yeah.
Yeah, it takes a very different kind of person to consciously breach
Your
everything
contract.
that's there.
Yeah, and Singapore is very small, right? So if you
Yes.
continuously breach your
Yes.
contracts, people are going to know.
Yeah, but let's say, for example, the person that you sign an NDA with or any agreement is overseas, and I
Yeah.
think this might be on top of the heads of some people who are thinking of expanding regionally, for example. We need to think of how enforcement is going to take place overseas. Is it even realistic to have your documents here in Singapore, governed by Singapore law, get a judgment by the Singapore court, only to realize that your counterparty has nothing here for you to enforce on? No assets, for example.
Right.
The force of a right that you have is only as good as how it can be enforced.
Okay.
And enforcement usually will work if there are assets. You enforce on the assets, for
Yeah.
example. You have to be able to hit them where it hurts. If it's back home, you have to make sure that anything you get here can be enforced back home easily.
Right.
Yeah, so we have had to turn away people sometimes, not because it cannot be certain documents cannot be done, but because it doesn't make commercial sense.
Yeah.
Right? Even though it's in our interest, definitely in my interest to draft a lot of stuff and charge you for it.
Yeah.
But ultimately, you might end up with a paper tiger. What is the point then?
Yes. Okay, just a very interesting point to note that in Singapore now, one of the key things that people are looking at is to resolve through mediation, right? And we've heard from some lawyers that it is a best practice, for example, to put mediation in your contracts. Is that something that, you...
Okay, when it comes to the dispute resolution mechanism, you have usually most generic one, that everything, all disputes arising out of this agreement, household arising, wherever arising, for example, will be decided exclusively by the Court of Singapore.
Yeah.
So that means litigation is your dispute resolution mechanism. You can, of course, have the alternative of ARD, alternative dispute, ADR, alternative dispute resolution, which is arbitration, mediation, and so. So you can have those, but the fact is, even if you have the court clause, nothing's going to stop you from mediating.
Right.
But you can always state in a tier form as to which is the last resort and which you should resort to first. That parties will endeavor to reasonably come to an agreement. Yeah.
Okay. Well, before we end off, we have some time left. Maybe two last questions. One from Aaron Jiang. Could you give us some examples of litigation cases between startups and investors, and perhaps how they could have been avoided in the first place?
Okay, I'll anonymize these, of course.
Take some time.
Yeah.
In the meantime, let me do a shout out to our partners, E27, General Assembly, Startup Bootcamp FinTech Singapore, and of course Samuel Ng from BlackOak LLC. We are from Asia Law Network here again, and we're doing a series of Facebook Q&A live sessions with lawyers this entire month. So please go on to x.AsiaLawNetwork.com/FB Live to sign up. You can also find these live sessions on E27's Facebook page, on Asia Law Network's Facebook page. And yeah, please also put in your questions in the comments box below, because beyond this session, we'll be trying to answer your questions after this. So sorry, Samuel, back to the question.
To be honest, I've not seen that many sort of full-blown litigation cases between startup and investors, and the usual reason is because of cost. It's not worth it for the startup to pursue the investors.
Right.
For the investors to pursue the startups, you might not get anywhere either, because the startups have nothing to give you.
No assets.
Right. But disputes do arise, and sometimes they arise because angel investors or just private investors in general, they work with a startup, and then they take that idea or whatever they have there, and they have another investment in a very similar startup. Yeah. that's where the whole idea of your NDA and your agreement, your investment agreement comes into place. You might want to negotiate for exclusivity,
Right.
such that if they are invested with you, they should not be invested with anybody else that's your direct competitor. Yeah,
okay.
because people like to hedge, they like to put bets all over the place.
Yes.
But that would not be to your
Actually,
interest.
some of the
of
bigger
course.
funds do that, right? I mean,
Yeah, they do. So you have to approach with some caution sometimes.
So if you have an investor or a VC that is very big and they invest throughout the region in specific startups, you might want to take into consideration what Samuel just said, right? So NDAs, when it comes to protecting maybe your the certain area they're in or the industry they're in.
I would think the NDA will come in when you've already reached an intermediate to more advanced stage of negotiations with the VCs. Again, I can't stress this enough. Don't bring the NDA to the first meeting.
Yeah, not the first meeting.
It never works.
And just don't reveal numbers that are sensitive to you, right? Like we can reveal that later. Okay, sounds good. So we have a question coming in from Alan Yip, but we're not going to answer that because that is relating to the 30th November session, which is on raising funds. So there is a new mini IPO in USA. Is it a better choice to raise funds via mini IPOs versus equity crowdfunding? There are many companies raising millions via mini IPO. Okay, that's a very interesting question, but we'll have to keep that for the 30th November session, so watch out for that. From Elgin E. Is the non-compete clause enforceable in Singapore? If you are in a very specialized trade and you can only work in this industry, with the non-compete stand, can you work for competitors in the same industry?
Okay, this is a perennial problem for companies, big or small.
Yes.
Competitors exist all the time. You have some of your best employees, for some reason unhappy with you or whatever, leaves your employ or gets poached or just moves to another company in general. What do you do then? He's going to bring his whole wealth of experience there immediately after his last day of work. Notice of 7 days. After that, he leaves. Your top salesman is gone, and all the customers follow him. Oh dear. Yes. So people try to lock employees down with non-competition clauses.
Right.
Non-competition clauses just means that for an amount of time after you leave my employer, you cannot work for a competitor. Now, you have to be very careful when you deal with non-competition clauses because under Singapore law, such clauses are viewed generally with quite a bit of disdain.
Right.
The law doesn't look favorably on clauses that seek to curtail the liberty of a person to work.
Okay.
It has to be very well circumscribed and well defined, and I'll tell you how detailed it needs to be. If you really want it to pass muster, it has to be as small and narrow as possible. This could mean that it comes down to duration, to industry, to trade, to even geography. For example, if you are, I don't know, specialized trade, let's say you're a doctor, you open a clinic right next door. Now, clearly, I think that would be against your interest if somebody does that, right? So that's where geography comes into play. One possible way to make your clause safer is to state upfront who your competitors are. So you already have neatly defined who these people are that this person's not supposed to work for, for say 3 months after employment or 2 months after cessation of employment. And last thing to note, the Singapore court will not reword your clause for you.
Okay, what does that mean?
It means that if it's not valid, they will strike the whole thing down.
So if you don't word your contracts properly, basically it does not exist.
Yeah, for the non-competition clauses. They can only cancel out things, but they cannot rewrite the contract.
Right.
They cannot rewrite an agreement that was arrived between two people. But if it's not valid, the whole thing will disappear.
Okay, so if you do not word carefully who your competition is, where the jurisdiction is,
you might have no clause in the end. When you try to enforce
it's equivalent to nothing almost, right?
Yeah.
Okay, that's very important. So maybe you would like to look into all your employment contracts and review that. And thank you very much. We have lots of support today, and thank you for watching. Thank you, Samuel, for coming to join us today. It's been a pleasure to have you.
Oh, it's been a pleasure to be here. This is a very new experience for me.
Yeah. Okay, we have any last words from you, Samuel, maybe?
Get a lawyer.
Get a lawyer. Okay, you can actually get Samuel for a quick consult on AsiaLawNetwork.com. Please go to AsiaLawNetwork.com, click on quick consult on the top right-hand part of the window. You'll be able to find Samuel for startups and advice. That's it. And we would like to thank all our partners. AsiaLaw Network would like to thank E27 for publicizing this. We'd also like to thank General Assembly for partnering up. Also, Startup Bootcamp FinTech Singapore for your support. Next week, we discuss data privacy with Jeremiah Chu from Lee & Lee, where he gives practical tips and answers to your questions on PDPA and more. So you can view our post on our page as well as on E27's page after this, and we'll post all relevant links that you've heard just now on the page. So let us know what you think in the meantime. Keep the questions coming, put it in the comments box, and we'll have a follow-up article on this to try to answer most of the questions. Thank you once again for your time, Samuel.
No, thank you. Thanks for watching, everybody.
Yeah, I'm sure we'll have you again very, very soon. Thank you very much. Thank you to the team for your hard work and your support.